might be worth beginning now. We seem to have a goodly audience. A few people may come in later on, students being what they are, they probably only just got up. So we'll just have to make allowances for that. Right. Without further ado, I will introduce our speakers. The motion before us today is that Corpus Juris, which is a proposal in essence to form some form of harmonised or common European legal system, would be, in the words of Kate Hoey MP speaking for the government, a threat both to Britain's human rights and to our national sovereignty. We are very fortunate in that we have possibly the two best possible speakers on this issue. We have Torquil Dick Erikson, who has come all the way from Rome in Italy to speak to us this evening and put forward the case against Corpus Juris. And we have Professor Spencer of Selwyn, who is a professor at this university, and who I believe helped to draft the document and who should be able to give us an unparalleled insight into what it really means. So, as I said, without any further allocation on my part, I'm not who you come to hear, I will introduce Torquil Dick Erikson.
I would like to say, to start with, I'm very grateful and aware of the honour that I am being done by having been invited here by my hosts, and also to speak on this momentous subject in Churchill College, named after Sir Winston Churchill, who led this country to resist a previous attempt to introduce an alien legal system upon us. A successful attempt, a successful resistance, I'm glad to say. I'm also here rather conscious of being an Oxford man invited to Cambridge, and I recall that in 1933 there was a very famous debate in Oxford on the motion this House would not fight or will not fight for king and country. I don't know what the arguments were, but the motion was carried, and it is said that Hitler and Mussolini were emboldened in their plans by this result. The same year, Oxford lost the boat race, and this induced Churchill to say, can't row, won't fight. So in some way, I am hoping to restore the, I won't say prestige, but the reputation of my alma mater. I also wish to thank Professor Spencer for having kindly come to defend, to give us the opposite viewpoint on Corpus Juris, because it has been very hard to find anybody in Britain willing to do that. As Tony said, the government's position is, this is a letter from Kate Hoey to an MP, with the ostensible aim of assisting member states to tackle fraud against community budgets, the Corpus Juris proposals envisage far-reaching changes to judicial cooperation within the EU. Many of the proposals would not be easy to square with the legal traditions of this country. Indeed, some would have implications for national sovereignty and human rights, and I can understand your constituents' concerns. This is rather, and she is measuring her words, this is rather strong language coming from a minister of a declaredly Europhile government. And even the European movement, British branch, responding to Idris Francis, who is here with us today, I have the letter he gave me. They say, he sent some of my arguments to them, and they say, Torquil Dick Erikson seems to have written his article as if the report had the force of the Commission behind it, the member states of the EU were planning to adopt it, it would be applied to all areas of national law and not just fraud against the EU budget. None of this is true, they say. So their line is, it's not going to happen, it's not true, it's just a think piece, it's just an exercise by some academics wishing to while away a rainy afternoon, it seems. I will, however, show that the situation is actually very different. In fact, the documentation is complete, that it will be that Santerre and Frau Theato chaired an interparliamentary conference in Brussels 9th, 10th November to consider Corpus Juris. They announced at the end, Mr. Santerre said, and this is a contemporaneous note by the legal advisor to the House of Lords Committee of Investigation into Corpus Juris, who was present, said that he drew attention to the powers that the new Article 280 of the Amsterdam Treaty, and I'll be saying a few words about that later, would give to take measures combating fraud, because Corpus Juris is limited in its scope here to fraud against the European Union. And Madame Theato says she thought the Corpus Juris was on the right lines and regarded the creation of the European Public Prosecutor, that is the central proposal, the European Public Prosecutor, as unavoidable. So there is a conflict which has not been noticed by public opinion. The European Union is saying this is unavoidable. The European Public Prosecutor, who will have overriding jurisdiction throughout the territory of the Union, and we will look at his powers in a minute, is unavoidable. The government is saying, and even the European movement, British branch, is saying it's impossible, it's not going to happen. They have said that Article 280 provides for measures against fraud to be introduced by majority voting, and we've ratified that. The government is relying on a one-line safeguard within Article 280, which says these measures shall not concern the national administration of justice. But Frau Theato has already stated how they are going to get around that. She says, the limitation provided for in the last sentence of paragraph 4 of the Article 280, these measures shall not concern the application of national criminal law or the national administration of justice, covers only the law currently in force in the member states, which may not be repealed or amended by community law. It does not, however, prevent the community from introducing supplementary legislation to fill gaps in national legislation in accordance with the subsidiarity principle. So, if there is a dispute, the government says this argument they don't agree with. But this is the argument that the European Union, with all its force, is going to bring forward, as Santerre has already announced. The only thing one can presume they are waiting for is for Amsterdam to be ratified by all the signatory states, and therefore it will come into force. And when that happens, we have no reason to think that Santerre will not fulfill his promise and introduce this measure against fraud. Kate Hoey said it's ostensibly just against fraud, and in fact the use of ostensibly is justified because this program, which was distributed at the seminar in Spain where Corpus Juris was presented in April 1997, where I was present, this program says objectives. The objectives of the seminar are twofold, to call the attention to it, and secondly, the organisers wish to make known the content of Corpus Juris for protection of these financial interests, which has been conceived as the embryo of a future European criminal code. Now, perhaps we should be aware, very briefly, of the fact that these islands off the northwest coast of Europe have a completely different legal tradition from the continent. This is a book by Professor Italo Mereu, who is an Italian professor of the history of law, who teaches at Ferrara University, and it's called The History of Intolerance in Europe. It is the Inquisition as a model of legal violence. He writes regularly for the Italian equivalent of the Financial Times, and it shows that when in Britain we were having Magna Carta in 1215, which puts which includes the right of trial by jury. A man shall not be punished and exiled or trampled on, save by judgment of his peers. On the continent, the Inquisition was being created, which meant essentially unifying the function of prosecutor with that of judge. And the Pope of the day, Innocent III, wrote very rude letters, documented by Professor Merrill, to the English bishops and abbots who had signed Magna Carta. Well, perhaps I should move straight on to Corpus Juris itself. It reads like a mini criminal code and code of criminal procedure in 35 articles. The first half is devoted to creating to defining the offences of fraud against the European Union, and the second part, which is the part I will be talking about, defines the procedures, the personnel, and the powers. It creates a single judicial area for the whole of the EU, subject to the laws which are laid down here. This is, by the way, a proposal, so it's not yet law, but they have announced, as I said before, that they're going to bring it in. And we will not have a national veto under the procedure they are intending to bring in. And they want it, and they want it strongly. The conference in November was attended by Lord Goodhart and Humphrey Malins, MPQC, for Britain, and Humphrey Malins wrote a letter to the Daily Telegraph on the 1st of January saying he was horrified. All 14 other member states said, right, fine, we'll have it. They'd already been briefed beforehand. He hadn't. He was given a questionnaire saying, to what extent are the population of your country aware of the need to have a harmonised criminal system for the whole of Europe? Well, so it creates a single unified legal area, and it sets up the European Public Prosecutor, who has the power to investigate and the responsibility of investigating crimes of fraud against the European Union. I would just look briefly at his powers. Going straight to Article 20, powers of investigation of the EPP, the European Public Prosecutor. Section 3, subsection G. To make requests for a person's remand in custody or remand on bail subject to conditions for a period of up to 6 months, renewable for 3 months, where there are reasonable grounds to suspect that the accused has committed one of the offences defined above, Articles 1 to 8, or good reasons for believing it necessary to stop him from committing such an offence, or from fleeing after committing it. Now, he then says, this order, at the beginning of the paragraph it was a request, but now it becomes an order. This order, in writing and giving reasons, must be addressed to the competent national legal authorities. We look at the French, which is the original, because the English version is a translation, as it says on the back cover, supervised by Professor John Spencer. It is, when it says to make requests, it says la demande. And when it says this order, it's still cette demande. I'm not quite sure, but doubtless Professor Spencer will explain why this different translation. Because he makes this request, according to a subsequent article, to a new figure called the Judge of Freedoms. Shades of George Orwell, I thought, but, rather an odd name, but the Judge of Freedom's duties are listed, but they do not include any scrutiny of prima facie evidence. So, the person can be kept inside for up to 6 months, and there is no provision for a public hearing within 24 hours, as there is in this country. So, habeas corpus has gone out of the window. And it says a period up to 6 months, renewable for 3 months. It doesn't say how many times it's renewable. So presumably it's renewable 3 months at a time as long as the investigation has to go on. It doesn't say renewable once for 3 months. It leaves it open. Now, so habeas corpus, which was introduced in this country in the 17th century, and according to some authorities was the king's attempt to violate it was a major cause for starting the Civil War, is abolished. In fact, on the continent, it has never been known, habeas corpus. People are arrested, put in prison, pending investigation, and there they wait and they're interrogated by the investigating judge, because the investigator is a judge. In an exchange of letters which I had with Professor Spencer indirectly in the columns of the Daily Telegraph, that was his letter appeared, I think, on the 2nd of December last year, and mine on the 4th. He said that the European Public Prosecutor is not a Napoleonic figure. I said he is, because if you look at the French original, it says Ministère Public, and this is some creation of the French the power system that they have is all there. It's absolute. We are in the lap of the on the continent. People are in your freedom is in the lap of the career judiciary, because one member of the career judiciary, who is the prosecutor, orders your arrest, and then his colleague, who is the judge, validates this order or doesn't, but they work in tandem on case after case after case. And there is no public hearing for a very long time, until the trial itself starts. When the trial itself starts, it says, and here we have another English centerpiece of our whole system of justice. It says, the courts, judgment stage, Article 26, paragraph 1. The courts must consist of professional judges, specializing wherever possible in economic and financial matters, and not simple jurors or lay magistrates. Not simple jurors or lay magistrates. Now, Professor Spencer said in his letter to the Daily Telegraph that the Roskill Committee, that this is a British proposal, because the Roskill Committee had already suggested that. It so happens that I was just by mere coincidence, I was at prep school with a member of the Roskill Committee who represented the minority position, Walter Merricks, and I met him afterwards, and he said, he told me what had happened. The Roskill Committee was a group of lawyers appointed by the government to give an opinion. In fact, they produced two opinions, a majority opinion, which said, yes, we think that fraud is too complicated for the ordinary person to understand, and a minority opinion, which was that of Walter Merricks, which was that, yes, but however, it's very important because, an argument I think which is crucial, is you can't have somebody put into prison for reasons that the ordinary person can't understand. I mean, think about the man's mother. You know, who goes, why did you put my boy? Oh, sorry, Mum, we can't possibly explain it to you. You couldn't possibly understand. You've got a law degree. No, well, then, just forget about it. Are you an accountant? No, no. I mean, you can't put people in prison if the man in the street can't understand. If you do, it's tyranny, it's despotism. For the English man, on the continent, they do. They don't have juries. They don't have independent juries. Well, even the sort of partial jury court, which you have in the continent, where the judges go into the jury room with the jury people, and the summing up is delivered there in private, and they can say whatever they like, and they can make, they can turn the jury people around any way they want. Because here, if a judge in his summing up gives his opinion, it's an opinion of guilt, and he gives it very explicitly, and after the jury produces a guilty verdict, you can overturn the verdict on grounds of an appeal, on grounds of undue influence by the judge on the jury. That's correct. But on the continent, undue influence of the judge on the jury. It's contradiction of terms. That's what the judge is there for. He's supposed to influence the jury. He's supposed to guide them, to tell them what to do. So, I just wanted to read a few words here from his book, Trial by Jury, by Lord Devlin. Jury as lamp of freedom. And Winston Churchill, in whose colleagues we are, actually mentioned trial by jury in one of his wartime speeches to the nation as one of the values that we fought to defend. Because the British, well, the English-speaking nations of the world have a conception of democracy which I call two-legged. That is, the ordinary people intervene in public affairs twice. Once, by deciding who shall write the laws, and secondly, by deciding when those laws are applied against an individual most violently, that individual's rights are taken away and he's locked up. The ordinary people say, a random sample of them in the jury, are asked to say a decisive word. It's not the state. We don't hold with the idea that the state can lock people up. We think that's undemocratic, and we think that's wrong. And Devlin, we wrote this, I think, in the 50s, or perhaps the 60s. He said, but it's prophetic almost, he said, each jury is a little parliament. The jury sense is the parliamentary sense. I cannot see the one dying and the other surviving. The first object of any tyrant in Whitehall, he hadn't thought of Brussels, would be to make Parliament utterly subservient to his will. And, in fact, under the treaties, Parliament is. I mean, the laws made by Westminster are, if they're in conflict with laws made by Brussels, the judges' instructions now are they have to apply the laws made in Brussels and not those made in Westminster. So the first object of any tyrant in Whitehall would be to make Parliament utterly subservient to his will, and the next to overthrow or diminish trial by jury. For no tyrant could afford to leave a subject's freedom in the hands of 12 of his countrymen. So that trial by jury is more than an instrument of justice, and more than one wheel of the Constitution. It is the lamp that shows that freedom lives. To many of us, the boundaries between Whitehall and Westminster are uncertain and confused. We are anxious that government should be strong and yet fearful lest the gathering momentum of executive power crush all else that is in our state. We look for some landmark that we may say that so long as it stands, we are safe. And if it is threatened, we must resist. It is there, this beacon that 7 centuries have tended. These are the words of the, and then he quotes in Latin the first, the line of Magna Carta, section 39, which says, I said before, that no man may be dispossessed or punished or without judgment, legal judgment of his peers. These are the words of the Great Charter which Blackstone said secured to every Englishman that trial by his peers which is the grand bulwark of his liberties, and which he took as the text for one of the most celebrated passages in the commentaries. His words today are still, after 2 centuries, as fresh and meaningful as when they were written, and I wish in closing this subject to commend them to you. He then quotes a paragraph from Blackstone, which I won't read the whole of. But these values, these liberties that British people have fought for over generations and indeed centuries, and many have laid down their lives for, are now, as I see it, under threat. So I think that the most disturbing thing, if that were possible, is the fact that this is all happening in silence. And perhaps on this, Professor Spencer does agree with me. He says, when he wrote to the Daily Telegraph and complained that he once offered to write an article for it, and they were not interested. That was some months ago, I presume. So it is important that Corpus Juris be talked about and that people come to know it. This is very important because it is an official proposal, and they have promised they are going to bring it in via a route which does not admit national veto. Thank you.